Welcome everyone to, we're going to call it the duck session. If it looks like a duck and walks like a duck and talks like a duck, it's not a duck, right?
It's not
a duck.
I was talking with Nicole and she said, I'm never doing moderating an afternoon session again. I guess she likes to skip out early. And I said, well, Craig always makes me do the afternoons. I think it's so he hopes I stick around to help clean up. But I'm John Call. I work for North Ogden City. Yes, Craig's my dad. We don't always see eye to eye on everything, but we do help each other out quite a bit. I'm an attorney by trade. I'm the city manager. I also do IT support here and at the city. I just kind of do a lot of things. But we've got a fun topic today. It's been something that's been pending a lot. Supreme Court finally gave us an answer. Nate with Snow Christensen and Martineau actually argued the case before the Utah Supreme Court. This was the suit where they sued Pleasant Grove City about the transportation utility fee. Basically, every landowner in the city paid a monthly fee to Pleasant Grove, which was dedicated for roads set aside specifically, and they were challenged by some residents and some interest groups, which are basically all residents too, right? Nate, they live there.
Yeah.
But so we'll go into that a little bit. Cameron Dill with the Utah League of Cities and Towns, the executive director, is going to give us a little bit of a hey, what's coming with fees and kind of the ripple effect of this lawsuit and the Supreme Court's decision. And then we're going to jump over to Jordan with the Property Rights Ombudsman's office. He's the lead attorney there. And he's going to give us some information about fees and decisions that have come through their office, or just even requests for decisions and advisory opinions. And then Susie's going to bat cleanup. Susie is a consultant with Zions Public Finance. Most of you know her. If you've done anything with finance in the state, you probably had Susie in your council meetings, or one of her competitors, but she likes to think that she's better, which is just great, because she is. That sounds terrible. We love Susie. So we'll just kick it off, and then we're going to try and leave some time for questions and answers, because again, this is kind of that walk like a duck, talk like a duck. And I think that you'll have questions about what does this mean, even some scenarios, and we'll try and do the best we can to answer those questions. But Nate, go ahead.
So like John said, my name's Nate. I'm a shareholder at Snow Christensen and Martineau, where I mainly do land use and government defense, but I also do a little bit of appellate work. And so Jody Burnett and Rob Keller handled this case below, and then Jody retired, and then Rob said, I don't want to argue this to the Court of Appeals. And so he gave me the case to argue. And as luck would have it, right after he turned it over to me, it went from the Court of Appeals back to the Supreme Court. There's a process by which they can refer things or take things back that have been appealed. And so suddenly the dynamics of my role changed dramatically. But what we're going to do today is, I think we're trying to start out our presentation very small and talk about transportation fees. And we're hoping to broaden it out to other types of fees, including, because of the audience in this conference, into planning and development fees. And so we've structured our presentation today very much as a dialogue or a discussion. Feel free to cut any of us off or ask any questions, especially given this small forum when we're talking with Susie. We thought it would be really good to share ideas about fees and the different types of challenges that we see. But with respect to this lawsuit and this particular fee, how many of you are familiar with the Utah Sage versus Pleasant Grove's case? How many of you read it? Okay, that justifies talking a little bit about the background. Pleasant Grove was really struggling with the condition of its roads through the 2000 and 2010s. And they had commissioned a study in 2012 that suggested that 41% of their roads were in very poor to failing condition. And the trajectory looked like it was just going to get a lot worse. And they also had a significant shortfall in terms of the revenues available to repair and maintain their existing roads. And so they tried a lot of different approaches. That first, there was some state legislation, and then there was a second approach where they tried to have a citizen-sponsored ballot initiative that would have authorized taking $2.2 million from the general fund and putting it into a fund to be used for road maintenance. And no surprise, that failed miserably. People didn't want to take funds out of the general fund. And so after talking about this issue back and forth from 2012 through 2017 and into 2018, eventually what they decided to do is adopt an ordinance that created a transportation utility and authorized a transportation utility fee that was divided into 3 different tiers. And those, if you fell within those tiers, you would pay it on a monthly basis. So if you're residential, it was $8.45. If you're business tier 1, it was $41.27. And if you're business tier 2, it was $236.06, at least in the ordinance. There were some changes later on. But, and really it was designed to address the narrow and specific purpose of fixing the city's roads. And that was really important for us in the litigation because of some of the arguments that were made. Because immediately after this ordinance was passed and there was a resolution, there was a challenge by a citizen and some citizen groups, some companies, that basically said 2 things. The first argument that they made was the city didn't have legislative authority to even adopt a fee in the first instance. And we think that that was probably because the organization that was supporting them was Libertas, and it was a more fundamental question to them than just an $8.45 monthly charge to use the city's roads. And the second argument they made is even if the municipality had the authority to levy that fee or create a transportation utility, that it was an impermissible tax as opposed to a fee. So the district court agreed with us, or Jody and Rob, that the municipality had the authority to create a transportation utility and adopt the fee, but the court also concluded that it was a tax instead of a fee, relying on an interpretation of the V1 oil case. How many of you are familiar with V1 oil? Everyone else here is very lucky. V1 oil is a case that was decided a long time ago. It really does try to delineate some boundaries between what a fee is and what a tax is. But if I'm completely honest with you, to me, it's still as clear as mud. And I avoided an oil joke there, just for the record. So we appealed, went to the Court of Appeals, and then went to the Supreme Court. And the argument was really interesting. The justices, Justice Hagan and Justice Pierce, were very interested in this question of like municipal authority and the distinction between tax versus fee. And you got to picture me, like, I've been out of law school a little bit of time, but you know, it's like my second or third argument to the Utah Supreme Court. I'm just getting grilled by Justice Pierce, and he wants to know what the limits of the rule is. That's what appellate practice is, really. And he's asking questions like, well, could the city just adopt a police fee? Could the city just adopt a fire fee? And the whole time I'm getting grilled on this point, I just say, Cameron, this is probably not an answer you want to hear if you need to plug your ears. I said, well, yes, Your Honor. You could totally do that fee under the existing standard. The distinction would be whether or not that fee is reasonable. And I think that municipalities may be hard-pressed to show that it's reasonable or figure out how to define that fee in terms of a specific service. But that doesn't mean that it's just automatically a tax because it's designed to collect police revenue, for example. And so the Supreme Court decided the case in our favor. Pleasant Grove won. And they said basically there are 3 takeaways from the decision. The first is that municipalities still have pretty broad purview or broad authority under the general welfare statute to enact measures that are designed to improve the public health and safety and quality of life of citizens within their municipality. And in doing so, what the court fell back on was an older decision that said, well, the general welfare statute is designed to give municipalities the power to address specific grants of authority and things that promote the general welfare. And the other side had argued that if there was a statute in place that specifically authorized some things, but not other things, for example, there was a statute that authorized the creation of certain types of utilities, but didn't address transportation utilities, that a city couldn't do that. And the Supreme Court said, no, that's not what we said before. We rejected the Dillon rule that strictly construed the scope of municipal authority, and we've broadly construed the general welfare statute to allow municipalities to creatively deal with and address local problems. The second takeaway for this case is, what is the line between a tax and a fee? And this is something that, this is kind of like, it's not the most important thing we're going to talk about today because it's thick in the weeds. But the big difference between a tax and a fee is the tax is designed to raise general revenue, whereas fees are characteristic of one of two things. The first is some fees are designed as regulatory fees. They're designed to offset the cost of the municipality's regulation of a particular person or entity, and those fees should be reasonably related to the cost of regulating. The second type of fee is a specific benefit fee. And a specific benefit or use fee is one where you're collecting a fee for specific use and you're using it for that use, and it should be reasonably related to the benefit or the need for that particular fee. Now, the thing that the district court did in this case is said, okay, you have a transportation fee, you have a road fee. Well, other people who are traveling through your municipality also benefit from your roads and the condition of your roads. And if that's the case and other people are benefiting, it's not a special use fee because other people are benefiting. And the Supreme Court said, no, that's not the analysis. The analysis is whether there's a specific person benefiting and a specific use for the fee, and where a transportation fee is being collected only for the purpose of transportation, it's being segregated from the general fund, and it's designed to be used by its benefits are designed to be used by a specific group that meets the characteristics of a specific use fee or a specific fee. And rejected the argument that just because somebody else might benefit, it automatically becomes a tax. At the same time, what the court did, and this is where I think much of our discussion will depend, the rest of today's discussion, is it said the fact that other people may benefit may still be relevant. It may be relevant to the question of the reasonableness of the fee, which is the third takeaway from the case. Reasonableness. What does it mean? And for some of you familiar with the Banbury case, was this just a question of going back to the future? Because what the court did in two footnotes, footnote 4 and footnote 5, is it cited some language from V1 Oil, which in turn cited Banbury, which if some of you know Banbury, it's a precursor to our Impact Fee Act. It sort of set the contours of what an impact fee or a development fee could look like. The court references that, and Susie will talk about the parameters a little bit more specifically later on, incorporates that standard. It says it's got to be reasonable. It doesn't have to be a precise mathematical formula. There might be other people who benefit, but ultimately the fee should equitably fall on similarly situated people and have some just relation to the person who, the basis for the fee. And so what does that mean? It means that we're in new waters, both with transportation and old waters, in the sense that it's the same old standard, but we have a court who is willing to kind of affirm a municipality's rights to do transportation utility fees. I think this is a great segue to Cameron.
Perfect. Thank you, Nate, both for the presentation and for your success before the Supreme Court, because this really was a big deal to local government. And the reason that this case is a big deal to local government is bigger than the transportation utility fee. How many of you in this room are familiar with the concept of home rule? Got a handful of you. Then Nate mentioned the Dillon rule. Neither of those apply to Utah directly. But the reason I bring it up is if you were to look at the jurisprudence, basically every other state in the country, cities are generally either home rule communities where they have certain powers that are granted to them from their state constitutions or through their own local charters. In fact, if you go to the next state over in Colorado, a lot of their local charters actually give them ability to have a different sales tax base than a neighboring city. So home rule brings with it its own types of complications. But home rule on one end of the spectrum really is empowering for local governments. And then the other end of the spectrum is the Dillon rule, which Nate referenced. And the Dillon rule is, the way I like to refer to it is basically mother may I. You have to ask the legislature for permission to basically act as a city. Utah is unique because our legal framework here in Utah is we're not Dillon and we're not home rule. We occupy this space where if the legislature has not preempted us as local governments, then we as local governments have flexibility to enact ordinances and regulations that fit within that general welfare concept that's in both the state constitution and in state statute. So we have that authority that courts have granted over really the last 40 some odd years. They've granted that deference to cities. So our first concern from a league perspective when this went to court was, are we as local governments going to lose some of that deference? And ultimately the court upheld that deference. So that's a really big deal for local governments. So now the question though is what comes next? Pleasant Grove was one of 13 cities that had imposed a transportation utility fee. Provo was the first. Those 13 cities are a fraction of the cities in the state. There are 255 cities, towns, and metro townships in Utah. So they've imposed it, and inevitably, we knew this would come. We've had legislators saying, well, if the court is now saying that it's okay for cities to do this, should we as a legislature step in and say yes or no, and under what circumstances? So shortly after Pleasant Grove won the litigation, the League Board of Directors, which consists of mayors and council members across the state, adopted these 8 core principles that then have guided us as we've been advocating in this space. I'll quickly run through these 8 principles. Principle number 1 is fee versus tax. So if there is going to be legislation in this space, it should recognize, it's on your slide a second ago, that distinction between the fee and the tax. And legislation should only be focused around the fee piece, recognizing that the legal standard for a fee is the specific charge for a specific service, which is the genesis of the transportation utility fee. Second key principle is that any legislation should be specific to the transportation utility fee. Third is functionality. The term of art that we came up with in discussions with our board was that any legislation should make the transportation utility fee process doable, not easy, but not impossible. So doable, but not easy. Number 4 is transparency. We're supportive of having a transparent process in order for a community to impose the transportation utility fee, and this gets to the reasonable piece that Nate mentioned, so I'll come back to that in a second. The 5th is the needs analysis. 6th is, on the needs analysis, you need to do some upfront work to demonstrate the specific charge for the specific service. So unlike with a property tax, where city elected officials could say, we're going to raise property tax, and it may be for this reason, it may be for that reason, maybe for this reason, maybe for that reason. With the user fee, there has to be that specific nexus, and that nexus requires, or we're open to it requiring a needs analysis upfront. And again, that gets to the reasonableness. Number 6 is local discretion, that local leaders should be responsible to set that fee amount. So we shouldn't have any caps in state law of what the transportation utility fee can generate. 7th is accountability, so there need to be parameters for how those dollars can be spent. We've had a lot of discussions around a dedicated account there. And then the 8th key principle is that the TUF should be a supplement, but should not supplant transportation revenues. In other words, this should be an add-on. It shouldn't be like a quid pro quo where, fine, you can impose a transportation utility fee, but therefore, on the other side of the ledger, you're going to lose gas tax revenue or you have to cut property tax. This should be an add-on. So with those 8 key principles in mind, we've spent the last few months deliberating with different stakeholders and with Representative Peterson around what potential legislation could look like. And ultimately, our preference would be really no legislation at all, because court case is what it is, the inherent fee authority is what it is, but we recognize we operate at the intersection of law, politics, and policy, and in this case, that intersection is likely going to result in legislation, in part because there will likely be bills this session to preempt the ability of cities to impose transportation utility fees. So if you look behind door number one would be status quo, door number 2 would be preemption, door number 3 would be, kind of back to the future with band bearing impact fees, a reasonable approach of how local governments can impose transportation utility fees. Let me touch on the reasonableness piece here for a second, because this is really, I think, the fundamental piece going forward, because the court has upheld that this is a fee, not a tax. The court has upheld that cities have this authority. The court was silent on whether or not Pleasant Grove's fee was reasonable. Is that fair?
It's fair, and I should have mentioned this, after we prevailed on appeal, the group that challenged stipulated to dismissal on remand. So we will never have a
Nope,
decision.
we won't ever know if Pleasant Grove is reasonable until the next litigation. But that is the policy question that's before us as local government leaders and before the legislature, is what is a reasonable transportation utility fee? We have 13 cities that have gone through the process, and they all look a little different. Nate mentioned the details about Pleasant Grove's. Pleasant Grove and Provo parallel to a degree, but there are some differences even in how those two cities approached it. Pleasant Grove, for example, has 3 categories of users. Provo's ordinance identified 8 different categories of users: institutional users, commercial users, residential users, and it was all based on data points related to traffic counts and ERUs and the like. So the different methodologies vary in different communities. If you were to ask me right now, what is the reasonable methodology around the transportation utility fee, my response back to you would be it would have to be reasonable based on the needs assessment in your community. There's not a one-size-fits-all. What's reasonable in Provo is going to look a little different than in Pleasant Grove. So when I was talking through those key principles a moment ago, toward the needs analysis piece and the transparency piece, they all fit into what is reasonable moving forward. As we've been discussing what potential legislation, hopefully to avoid litigation, would look like, there are 7 steps that, as of now, are on our kind of informal internal process, recognizing that we have some stakeholders that, again, would prefer not to see this fee go forward at all, and would prefer to see preemption. But the 7 concepts that we've been discussing are these. Number 1, that you would have to, as Cameron City, have a third-party study that would have some sort of regularity in the updates. So that gets to that needs analysis up front, whether it's Centerville, Farmington already has the fee, but Centerville, or South Ogden, or Layton, or fill in the blank city, Midvale. You'd start with the needs analysis up front. That may mean that there will be communities out there that will never impose the transportation utility fee because either the need doesn't justify it, or that needs analysis is a big enough obstacle that it's not worth going down that path. But that's the first piece, is there would need to be that upfront study. The second piece is that state law would reference the term reasonable relationship. So that, again, once you have your needs assessment, this is what Provo and Pleasant Grove did, identified we have this much in need and transportation needs in our community. These are different ways that we could go about doing it, depending on the different types of users and depending on the impact and the intensity of use of the property owners in the city. Then they would identify what that really reasonable relationship is. Then the third piece would be user fee for all transportation users. And that's a key point here, is the all transportation users. Because part of what distinguishes a fee from a tax is the fact that it is based on use. Think about property tax, for example. There are a lot of entities that are exempt from paying property tax. But in the case of a user fee, If it's truly a user fee, then anybody who uses the system, regardless of tax status, should be paying to use that system. Fourth concept we've discussed is the role of public meetings to review that needs study. The fifth concept is public meetings to approve the transportation utility fee. Now, those of you who've gone through a city budget process know that every year the fee schedule gets adopted. But there is interest at the Capitol of having transportation utility fee have an additional, almost above and beyond approval requirement. Now, what that looks like is still being hammered out. But my hunch is we'll get to a bill and it won't be good enough that it's just the fee schedule and the transportation utility fee is part of the fee schedule. I think there'll need to be something else as a piece of it. And part of the argument there gets to the sixth piece, which is an annual review. And this is actually something that came from the Provo ordinance. I believe it's the only one that has this in the ordinance of the 13 cities that have gone through this process to date. But Provo's ordinance requires their elected officials to look at the transportation utility fee every year and also look at the other transportation revenues that come into the city. And that's also what makes the transportation utility fee a little bit different than your traditional user fee. Because with your traditional user fee, the user pays it, and then there may be other local revenue sources that supplement the service, but generally speaking, it's all local revenue. But with transportation, Cameron City will have those local revenue streams, but Cameron City is going to get a portion of county option local sales taxes that have been imposed. Cameron City also gets a portion of the motor fuel tax. So there are sources coming in from other places, and we've talked about whether or not there could be an automatic trigger if, for example, the state were to increase the motor fuel tax. Would that automatically trigger that review of the utility fee? So these details are still being discussed, but all on the table. And then the last piece would be a dedicated account for the use of the transportation utility fee. Again, when you look at the different types of fees, some fees go in dedicated accounts and some don't. But the discussion around the transportation utility fee is that this would be a special codified rule for the transportation utility fee, which then also gets to the allowed expenditures of the transportation utility fee and having those dollars spent exclusively on transportation-related projects. We're still debating what that definition should look like. To me, the definition should be tied back to the needs analysis, but we're still working through those details and have another negotiation scheduled in a couple of weeks. So in a nutshell, that's where the litigation left off, because you guys won in February, right? At the end of February. During the legislative session, which gave me a little bit of heartburn, but it worked out. There were no bills filed those last few days. Yeah, no worries. No worries. But then over the course of the last few months, we've been working through what this sort of framework could look like that would still be true to our key principles here. Where it'll end up in the upcoming session, I think, is still up in the air, because there is a political concern from legislators of if they were to pass legislation, would that have the impression of the legislature essentially authorizing a new fee? Our response back to that concern has been, you're not actually authorizing anything. We already have this authorization now. If anything, the legislature is putting parameters around how cities can exercise that authority, which is the Back to the Future with impact fees from the Banbury case and the Impact Fee Act. With that, I'll pause there, because are we doing questions now or later? Because John shot out like a bullet out of a gun back there. John?
Will this transportation fee seep over and deal with our storm drain fees?
Yeah. Well, this is exactly why I said one of our key principles was to treat any legislation around the transportation utility fee to be exclusive to the transportation utility fee. Because we would rather not reopen the door to a discussion about all fees that cities impose under either type of categories that Nate referenced. But the stormwater utility fees come up quite a bit in the conversation, as have other types of fees that cities impose, which Susie will be getting into in a moment.
So to make sure that this fee, one of your principles being that all users need to pay this fee, is that going to include the LDS Church? Is that going to include, visitors? Is that going to turn every city road into a toll road?
So several questions there, and I'll start with the last one and work back. we've actually had quite a few discussions this summer around toll roads, what authorization exists for the state of Utah to do toll roads, and for local governments to do toll roads. A toll road, from a policy purity perspective, a toll road is the best transportation user fee there is, right? Now, from a practical perspective, there are all sorts of concerns with it, not least of which being that if you receive federal money, you can't toll existing lanes. A toll road can only go to added lanes and added capacity. So we had a lot of discussions around whether or not the long-term answer, not just for cities, but for the cities that state long-term, should be tolling. Ultimately, right now, I don't see a legal or political path to accomplishing that. The state is working through a road usage charge, and cities, starting this past session, are now going to be part of that road usage charge, and the state has to have a road usage charge program developed by 2030. Right now, it's in its infancy, and it only applies to alternative fuel vehicles. There are several thousand vehicles that are in that pilot program, but that is the long-term addition to the motor fuel tax, is the road usage charge. And ultimately, the concept there is tolling by another name, but where essentially we are tracking the miles we are using, the miles we are driving, and paying for the use of those roads and remitting it back to the state or local governments. So anyway, I think the tolling piece still very much a question. The second question about charging others and people who aren't part of the community, this comes back to the analysis Nate was describing earlier around whether or not the user fee has to be essentially 100% focused on all users or individual users. What the court said, the Supreme Court said, was even though there are people outside of Pleasant Grove who come into Pleasant Grove, use the roads and leave, so they're not directly paying the fee, there's still a reasonable enough relationship with those property owners and the people who are coming in and consuming the businesses or consuming the goods in Pleasant Grove, and those businesses are paying that transportation utility fee. That still meets the reasonableness standard, and so therefore it was okay, even though they weren't necessarily charging a fee when you crossed into city lines on the city road. And then the first question you asked about churches, this is another one of those sticky pieces of in order to be a user fee, it needs to be tied back to the use, regardless of who the user is. Now, where it does get tricky is you have a lot of entities that are property tax exempt, so they don't pay property taxes. And in some cases, they pay fees for use of different local government services, and in some cases, they don't. So this is something that will be worked out in the months to come if a bill emerges, is what does that mean for all of the entities who may or may not pay property tax and may or may not pay different types of use fees.
On Pleasant Grove's fee, I don't know how it was actually charged, to be completely candid with you, because I dealt with the aftermath. But what they did is they treated churches under a tier 1 as a tier 1 business, as opposed to a tier 2 business, reasoning that the intensity of use was just usually 1 day a week, as opposed to constantly, like a Walmart, for example. So.
And Provo took a slightly different approach, but again, that gets back to there are different ways you can meet that reasonableness standard for the methodology. Okay? Jordan.
Okay. I always have to. Cameron talks at a different level than me. He's like super fast, so I gotta like slow it down. But no, and I was asked to provide the ombudsman's perspective, right? That's why I was asked to be on the panel. So for those who don't know, our office, we're an independent, neutral agency that provides advisory opinions and mediates property rights disputes. Everything kind of related and flowing up to the Takings Clause, the Fifth Amendment, Article 1, Section 22 of the state constitution, things related to takings. And admittedly, when I was asked to participate on this, I thought, well, and we don't do advisory opinions on usage fees, right? We're focused on the development process, the land use application process. So when I was asked to participate on this, I thought, oh, they're looking for a free attorney to come and provide some perspective, right? Some ideas on something that's kind of related and adjacent to the area that we work in. Because again, the fees that we deal with are development related fees. So you have the impact fee, right? But otherwise it's application fees. And then, a lot of what we do is we talk to people on the phone. They ask questions related both to land use in the context of the development process, but also just general governance. And so we do regularly get questions about service fees, right? But usually it's in the context of like an application fee or a hookup fee. And admittedly, the farthest I've ever gone in really looking into that, analyzing it, reading the authorities is just to say, oh yeah, whenever you charge a service fee, you can only charge for the service provided and you can't charge them more than that. There's a provision in state law that says an individual can ask for accounting of a service fee to see how it's calculated, make sure it's only offsetting the cost of the entity to provide the service, right? And honestly, that's as far as I've ever gone, okay? But in looking at this, and so I read the Larson case, the Utah Sage case, thought it was interesting, but in really digging into the authorities, it became rather apparent that there are actually a lot of interesting implications for our office. So that's what I'm going to talk about. I'm just going to kind of talk about the implications. And really, it's all related to kind of takings implications, really, okay, in the context of an exaction. So exactions, as everyone in the room knows, the ones that I typically work with are development exactions. So anytime a developer comes in and they want to develop in some way, the local government can require the developer to provide infrastructure to contribute both property, right, through exactions like roads, sewer, water facilities, all of that, to the extent that it offsets the developer's impact on the city's ability to provide them services. So we're talking about the Nolan-Dolan rough proportionality test, right? There has to be a nexus, a connection to some legitimate government interest, and then you're looking at a rough proportionality analysis to make sure that you're only offsetting the impact of the developer's proposal and you're not offsetting the impact beyond their own, okay? That's the idea behind an exaction. And then an impact fee is a subset of an exaction. And the idea is that it's supposed to capture everyone's fair share contribution to system improvements. So those improvements that can't be attributed to any one individual or any one developer, but every new development contributes to, right? So you collect the impact fees, you pay and we have the Impact Fee Act, right? That kind of governs and lays out a process that local governments need to go through the impact fee facilities plan and the impact fee analysis that will hopefully on the back end spit out a impact fee that is roughly proportionate, right, to the impact of the proposed development. Now getting into the V1 case and the Utah Sage case, I was actually a little surprised, to be honest, to see that they were using all of the language that you would see that's talked about with relation to an impact fee, but they were applying it in the context of an ongoing transportation fee for maintenance. And one thing we always tell people is, hey, you cannot use impact fees to maintain roads, to change your level of service, right? For ongoing costs related to the usage of the road, okay? But you can do that with this transportation fee now under the new case law, right? But the same principles apply as I see it, right? So like Nate and Cameron said, when you're looking at this usage fee, so it's a fee for services provided, right? And whenever we're talking about, and they refer to it as an exaction, it is an exaction, okay? Anytime you are requiring a property owner to contribute something to the government, that is viewed as an exaction, whether that's a tax or a fee or dedication of property or otherwise, right? And so, getting to kind of the questions that were asked, one of the questions was, what are the rules for charging fees for local services? How can they be calculated, justified, and challenged? As far as how they can be calculated and justified, I think really the Impact Fee Act provides probably a pretty good model, okay? In that you have to ensure, what was the language, for a service fee to be reasonable, and so it gets to that question of reasonableness, right? The total cost of the service so financed must fall equitably upon those who are similarly situated and in just proportion to the benefit conferred. So really, and this is the interesting thing I think for our office and for what we do, is because we're kind of tasked with looking around and determining when are there takings implications, right? And so we look in terms of what is a lawful exaction and what is an unlawful exaction. So a lawful exaction, the courts have said you're basically just talking about a lawful exercise of the police power, right, to regulate for the health, safety, and welfare. So as long as you're only requiring the individual contributing the property to offset impacts that are their own or pay for services that they need, right, then it's a lawful exercise. But it's when you start having, when it becomes an unlawful allocation, right? What are the words used? An unfair appropriation or unfair apportionment or an unfair allocation, then that's when you start getting into the realm of potentially as a local government committing a taking of private property without compensation, right? And so that's kind of the takeaway that I got from all this is really in coming up with these fees, and the court has laid out that process, right? The analytical framework of first categorizing it, looking at the purpose, but then getting into the reasonableness and whether or not it's falling equitably upon those who are similarly situated and in just proportion to the benefit conferred. And admittedly, I mean, looking at what Pleasant Grove had proposed, I thought it looked pretty reasonable, right? I think they even contracted with LYRB, right? Mm-hmm. Which is what cities do when they're calculating impact fees. So, they identify all the facilities that you need that are, substandard, that don't have they establish like a PCI, right? So you're looking at what facilities do we need, and then you're ensuring that they're reasonable and that the fee is being proportioned equitably among everyone, right? So hiring an expert, having them help you go through that process, like you said, right? And then ensuring that so the city in this case came up with a methodology. They classified users based on the demand for the service. They quantified the user's intensity of use, and then they established a fee schedule that apportioned burdens for paying for the service in a way that addresses the classifications and intensities of the use. And I think that's what cities can do, again, with the guidance that we have of being reasonable, right? And reasonableness means fairly apportioned and equitably distributed. If you go through a process to show, okay, for each user, this is their fair share contribution, right, to the usage, then, again, for the guidance that we currently have in state law, I think that's what cities need to do to meet their obligation, right? Yeah, and that's kind of about all I have right now. I'll save the rest for later. But.
Yeah.
Well, as soon as this case came down, we started getting a lot of phone calls from cities saying we're ready to go full steam ahead on transportation utility fees. But those aren't the only kind of fee calls we've been getting lately. We have been getting a really lot on development fees as well. And several of our clients, especially cities that are rapidly growing, have found that the state auditor has been poking around, looking at some of their data. And so they are all asking the same question: are my fees reasonable? And they'll also add on, and are they defensible? And so what I thought that we would do is that we would look quickly at, and you've kind of gone through this, so I'm just going to skip through some of this, what the law has to say about
Sorry,
this.
bye.
No, this is good. Really hard from an attorney, because my thought was, we'll just go through, it's a little vague in the law, and then I'm going to just show a few examples of a few approaches that are different, that I've seen different cities doing. And I thought, I'm on a panel with 4 attorneys, let's put them on the hot seat and see what they think and what way should we go. So that's the plan for the next few minutes. Okay.
That wasn't part of the deal.
So we'll look at these wording carefully. And this
That's
is
what
under
I
the
prefer
development
living
fees. A
down.
land use municipality may not impose or collect a land use application fee that exceeds the reasonable cost of processing the application or issuing the permit, or an inspection, regulation, or review fee that exceeds the reasonable cost of performing inspection, regulation, or review. And then it does talk about, as Jordan mentioned a minute ago, that if requested by an applicant, you've got to show how you calculated that fee. And then some of the other requirements he mentioned were in footnotes to the Pleasant Grove case, and I will bring those up in just a moment. Okay. So before we put up a few examples here, I wanted to talk a little bit about the differences in fees. And how planning and the development fees, they present a unique challenge. So a lot of the fees that we do, you all have utility fees in your city, but it's pretty easy to project demand. Yeah, you don't know maybe how much you're gonna grow, but you do know how many customers you're billing right now and that you might grow by 2%, 3%, you've been growing by 70, building permits a year, 100, whatever. You have some idea of what that demand is gonna be, and you have some idea of the revenue. Yes, you've got your operating expenses you can project out, and maybe the capital costs go up and down every year, but you've had an engineer figure those. So you can have a pretty good plan going forward of what those fees need to be, and you can justify them. Even with things like business license fees, we know about how many businesses, we may bring in a few more, but we know the cost of the business license department. The transportation utility fees, and they, as they're, we've seen them done differently throughout the state, but I think most of us coming around the central approach of using the intensity of uses, which is often based on traffic counts, referring to the ITE manual, the Institute of Transportation Engineers, with the traffic counts and the intensity of uses by different use types, dividing maybe into different categories, but tying that back again to the idea of the use, that the fee charged is related to the benefit, the use with that. So what happens then when we come up with development fees? So we have a department that has pretty steady expenses. What happens to our revenues? They can be like a roller coaster. We don't know what revenues we're going to get year after year. And we saw them going up for a while, and now I was just sitting by Eileen from the Home Builders this morning, and she was saying she'd done an informal survey, and that the cities she had talked to, they were down on average, and cities would differ, about 23% in building permits this past year over the prior year. So that's a real, drop in revenue, yet you have all of these expenses that are not dropping. So that is something that we need to think about as I show these examples. What would the impacts be? So I'm going to look a little more at the development fees, and I'm delighted to get your opinion, you folks, on this. Okay, so there's 3 approaches that I've seen. One is an average of revenues and expenses over time. Another one, they review every year. They look at the prior year's expenses and revenues, and they use as a basis for the following year. And one that's a very detailed method where you calculate direct costs, indirect costs, supplies, all of that. So let's look at the first one. This is the one where they average them over time. And so you can see here on the colors, and they never come up on the screen the same as they're on here, but what I'm looking at, the blue are the revenues. See them falling off recently. These are fictitious numbers. Expenses generally climbing over time. And there would be some years where revenues exceeded expenses, some years where expenses exceeded the revenues. But on average, they said they were coming out even. Is that defensible or justifiable? So on average, it's come out. But it's one of my concerns is that the individual fees, having read the legal requirements, are not necessarily proportional to the services provided. This is overall for the department, and as you know, as you look at the list of community development fees, it can go on 2 pages with all the different types of fees that are charged. Is there enough of a relationship there? I'll put them all up before I ask these guys to react, okay? So then we have this other one. It's similar to the prior approach, but it's adjusted yearly. You may have had a year where you had excess revenue. You carry that over to the next year. What are you going to do to adjust your fees every year? Are we going to keep up with inflationary costs? Then we have this really detailed analysis of individual fees. So we're going to take for every single person that touches this type of fee, whichever one it is. It could be the attorney, it could be the planner, it could be, whoever's going to be touching, this, looking at it. What is their costs, their wages and benefits per hour? Then we've got indirect costs, overhead. We could take a fair share of HR's time, IT perhaps, because they're supporting the planning department. Indirect costs in their department for training perhaps, supplies, this cost of doing the study. Come up with a total cost per hour or per minute. Multiply amount times the amount spent for every different fee type, and you get a fee. But what is the big problem with this? What if you have 10 I'm going to use small numbers, 10 applications one year and 100 the next year, or 100 one year and you go down to 10? You still have all those employees in that department, and your cost hasn't changed, but your revenue has dropped dramatically. Can they be doing other things? It reminds me a little like the streets, the public works department, where we have all these employees that if it's snowing in the winter, they have something to do, they can snowplow. But if it's not, there's not as much for them to do. but their revenue stream remains constant. They're not reliant on fees coming in for this. So the city takes all the risk. I think this one, my opinion, is this is totally justifiable and defensible, but the city takes a lot of risk in this case and may not cover all of its expenses. So anyway, just a couple of other thoughts on this before I turn it back to the guys. But reasonable, these you've heard this, must be that equitably, we just talked about that too, and the class of people to the just proportion to the benefits conferred. It says they do not insist on exact mathematical precision. These are from the footnotes again to this, the Pleasant Grove case, which was a relief when I read that. And as I've talked to cities and they've tried to estimate the amount of time, you know, if they want to go that approach that they do for a certain fee, they'll say, this is so hard, they all differ. And it may differ depending on, you know, the type of development, the size, the location. But you know what they say is the biggest single factor in how much time it takes for generally for applications? The sophistication of the developer. And so, you know, these aren't exactly right, but we've averaged for a category. So the fee may be reasonable even if it raises revenue that exceeds the cost of service, which is an interesting one. It's unreasonable if it's not reasonably related to some need created by the one paying the fee. Or, and you talked a lot about that, the rational nexus, you know, between the fee charged and the benefit received. And if the services provided through the fee are not of demonstrable benefit to the one paying the fee, and they've covered that well. So anyway, before I move on here, can I just ask for any reactions, and I'll turn it back to John. Anything give you heartburn?
I mean, I think for me, the perspective I have is that whatever comes out of the tough fee is going to be the same rule that's going to be applied to all fees. Just meaning that it's narrowly tailored, but I'm wondering if they're going to pick one of these three methods and say, this is what you have to do for everything from Bowery rentals all the way up through, you know, all the other stuff. But that's just me. I don't know what the group feels.
I mean, I think it's the term that comes to my mind. It's really kind of the wild, wild west right now, right? Because with impact fees, that's how it went, right? I mean, local governments came up with the ideas as a way to offset the impact of new development, and then the legislature stepped in on the back end and kind of said, okay, you have to identify which facilities, and you got to go through a process, right, to come out with a fair share contribution. And again, reading the authorities right now, I mean, apparently Cameron doesn't like to hear this, but I was just talking with another attorney who couldn't make it to this presentation. He had to go somewhere, but he was asking me, hey, in light of this case, does that mean someone could charge a park maintenance fee? And the answer is yes, as far as I can tell, right? Or any other type of maintenance fee. And so, you know, whether or not the legislature just you know, leaves the authority, the general police power to the local governments to kind of responsibly pursue that and come up with, you know, through their governing process, reasonable fees that the property owners can live with, or whether or not they put in a process that looks similar to what kind of governs the impact fee, which really doesn't tell you the specifics, right, of how you calculate the fee, but it provides a process and factors that you look at, right?
I think the impact fee is really well defined. I think over the years we've come through with a pretty acceptable methodology.
Yeah.
I don't think we're getting a lot of pushback on that now. I'm seeing it more on how the accounting, if the cities have truly spent them for those facilities and all. So I'm with you on that, and that's why I'm just saying on the fees, they seem a lot more vague to me at this point.
Yeah.
I'm glad you said the Wild West.
Yeah, and I mean,
I'll play the devil's advocate on that point though, because I don't think it's as wild as, you know, Clint Eastwood though.
I'm thinking more John Wayne.
John Wayne, there you go. Because at the end of the day, we ask courts to apply a reasonable test in a whole wide range and varieties of contexts. And part of my practice is defending impact fees. And just because we have a statute with variables doesn't mean we're not fighting over rough proportionality, which is the standard that applies in that context. And really what the statute has done is increase the cost of doing impact fees. And because there are so many specific provisions, Greg's not in the room so I can say this, he's the class administrator in the case that I'm litigating right now. It's an invitation for mischief in terms of highly technical arguments that undermine the ability of governmental entities to fund public infrastructure, right? And so from my perspective, I think the standards are there. The standard is reasonableness. There's a measure, and what the court says in Banbury is, if somebody challenges your fee, you should disclose the basis for doing it, and then the burden shifts to them to show that it's unreasonable, right? And what that does to me, so I'm a litigator, I'm all about avoiding litigation risks so that I'm not in discovery fights with Craig Smith or something like that. But for me, I think I'm going to go to my clients and say, yeah, you can import some of the principles from the Impact Fee Act. You should be thinking about how will you justify this in court. Does it pass the smell test? Does it look like it's a general revenue measure? Does it sound fair in your heart of hearts? And can you explain it? And I think that the existing standards lend themselves to that anyway. But I understand that there's also some policy arguments and other issues at play for specifying. And Jordan, I just gotta say this, we gotta have a fight over whether or not this is really similar to an exaction at a different point in the day. when
They
people
use
aren't
those
trying to get on the
words.
road.
They called it an
So,
exaction. And I'll say, I will clarify, when I say Wild Wild West, I'm talking about in regards to factors to consider, right? Because we have Banbury for impact fees. And then with relation to, frankly, what types of maintenance fees you can charge, right? Because in the Impact Fee Act, we have the types of facilities you can charge an impact fee for. We don't have that right now, right, with maintenance fees. So that's why I say it's Wild Wild West as far as what cities might come up with that they could charge a maintenance fee for.
And I think my fear about that would be, when you look at a standard fee schedule for a municipality, it might be 18 pages long in a case like Pleasant Grove. Are you gonna require a municipality to do a fee study for their disinterment fee at their cemetery? You know, like, taken to its extremes, it could be really problematic for all of us as citizens and our local governments.
Well, I think there needs to be a distinction made between, so we talk about a specific service providing a specific benefit to a specific individual, right? I think that's easy with hookup fees and application fees, but frankly, impact fees and now these new maintenance fees, there's a different component there, and the court even acknowledged that, right? And that they said, hey, other people are going to benefit from these fees, right? So we're talking about more shared services or common facilities, and we have to parse out, okay, what is everyone's fair share contribution? I think those are the types of fees that we're talking about, and even making a distinction between the two. Because yeah, with this type, right, where you know exactly who the user is that's benefiting from the service, just keep what we got, right? But as far as these new ones, and I think that's why impact fees have the framework that it has around it, because you have this scenario where it's a shared service or a common facility, and you're trying to figure out, okay, what is everyone's fair share contribution, and that it gets fuzzy.
And I understand that, and I think that's a fair point. It's something fundamentally different. I just start to have a little bit of heartburn after litigating this case when something is specified as to what you can and can't do, and then it feels like we're returning to sort of a Dillon rule approach as opposed to the hybrid model that Utah courts have used in the past. But
Well, and let me finish here, because I think I want to answer Susie's fact pattern. I didn't have my glasses, but I think I was able to follow it closely enough. I would argue all three of those would meet a reasonable test, because depending on the life cycle of the city, depending on a variety of other factors, I think all of those could pass the test and may make sense for one community but not for another. And
They're all three, so I'm really.
okay, well, good. I'm relieved that I passed the test, but I think
But I'm willing to admit that if you said something else.
I have the privilege of representing more than 1,400 elected officials in the state. We've got mayors and council members from communities as small as Hideout up to cities as big as Salt Lake, with a lot of Nephis in between. And ultimately, when you think about that standard of reasonableness, there's the legal standard of reasonableness, which we've been arguing about here, and there's also that political standard of reasonableness, that ultimately those voters are the ones who elect those council members to make those decisions about how to invest in infrastructure and how to pay for services. And ultimately, I do agree that the transportation utility fee looks a little different than the other types of user fees that we've done in the past, and we've got the two different categories of fees. But I don't want to get to a scenario where every time a city wants to have a junior jazz program, that you have to go through a third-party analysis and hire Zions Bank to figure out exactly how much it's going to cost to pay the high school officials and all the pieces that come to that. That's the point of the reasonableness standard, is to give enough flexibility to actually govern, but still have a standard that you have to meet legally in order to be responsible with the fee payers' dollars that they're contributing to local government. So my hope is that the final bill on transportation utility fees is really nuanced and narrowly tailored to the transportation utility fee, because it is a little bit different than the other types of user fees that are out there. Inevitably, I think this type of conversation is a very healthy and productive one to make sure we're finding the right legal and political balance.
Yeah, and we are out of time. I don't want to keep you all here, so thank you.